If you are a California Uber driver and want to be an employee, I've got some bad news. A judge has balked at that request. For the time being, anyway.
Xbox, Twitter, Uber,
Postmates,
Netflix, MoviePass,
Google,
Facebook, eBay,
DoorDash,
Apple, Amazon, Airbnb,
The Apptrepreneur. Hey everyone, this is Kevin the Apptrepreneur. If this is your first time here and you happen to really like this video and want to see more content like it, please do me and yourself a favor. Click that subscribe button and ring that bell notification. You will be notified of our near daily uploads and recap podcasts on Sunday and premieres, live streams, all that jazz. It's a lot of fun, but you've got to subscribe and ring that bell first. So anyway, let's talk about Uber employee independent contractor status because, yeah, this is one of my favorite topics. It really is. I get so many interesting comments below. I will get more, and they range from either, yeah, you go get them, you tell them that we're employees, to like, how can you not see this is a bad idea? Guys, I see both sides of the story. That's why you come to me. That's why some people of you think that I'm a Republican, and some of you think I'm a Democrat. I am looking at all sides of the story. And you know who else is supposed to do that? Judges. Judges are supposed to be impartial, unbiased, and look at nothing but the facts. And Uber has had several lawsuits, including one fairly recently, where drivers are suing Uber to make them employees, partly because they opted out of arbitration, and they are allowed to do that, and also because of the upcoming AB5 law. But a judge in California has so far decided he's not so sure Uber drivers are employees just yet. However, before we talk about the rest of the story, please, if you have 5 minutes of time and you'd like to make $5, check out our sponsored link below from gigworker.com. They do surveys and provide information for drivers of Uber, Lyft, Postmates, all that jazz. And guess what? They need your help. They want to have the survey taken. It will be provided to news outlets like Vox and Vice, and they will give you $5 for your time. It takes 5 minutes. You just need last week's Uber ride count screenshot and a PayPal valid email address. Otherwise, just click that link below. You will help us out, and you'll get $5 on Saturday. So this is from Bloomberg. Uber judge balks at making drivers employees for now. So Uber Technologies, Inc. beat back an aggressive bid to force it to treat California drivers as employees. I'm just going to already state from the first sentence, one of the issues with the statement is it's like, well, I think the drivers are already feeling like they are treated like employees, that thus they want to get paid like employees and have the benefits like employees do. Uber holds a lot of power over them. They control a lot of strings. They force them to arbitration agreements. It's not a pretty picture. And they want to actually get what's owed to them for being treated like employees. So I think the sentence gets it wrong right off the get-go, and I just want to make it known. But the rest of the article is pretty interesting. But a judge's ruling may allow a long-running fight over pay and benefits to gain traction in 2020. U.S. District Judge Edward Chen declined Monday to order Uber to instantly convert drivers in its home state from contractors to employees based on an argument that it's cheating not just workers but also the public at large. But the San Francisco judge, which that's probably the most surprising thing about this, that this is being ruled on like this in San Francisco, also refused to throw out the case, an early test of a California law aimed at gig economy companies that's set to take effect January 1st. In what may turn out to be a significant threat to Uber's business model, Chen concluded the case presents, quote, a plausible claim that any misclassification by Uber is willful. So what is this saying right now? Like, what is going on exactly? Well, again, I'm not a lawyer, I'm not a judge, so I might be just a little off. But from what I am understanding, the judge does not think there is sufficient, at least the arguments he's heard so far, do not convince him that Uber should make all their independent contractors employees. He doesn't feel like the arguments are strong enough at that point. However, they are strong enough that he wants to look at what they're doing and some of the changes they're making, and there's enough evidence there that, well, that the case is showing that the misclassification by Uber is willful. He thinks that it might be there, and to what he believes it is there, he believes it might be willful. So therefore, it's not ruled on yet, and in fact, it might even go to trial, which, by the way, I think this is what more judges should do. I've been following a couple other legal cases, small-time legal cases, that I'm not talking about here because they don't have anything to do with the gig economy. And I've seen judges make, well, okay, one's a small time, one's a big one. But I've seen judges in both these cases actually throw things out and make claims on things that honestly are very debatable, where I'm kind of thinking like, I don't think the judge should have the power to make a claim on that. That seems like it should be tried in front of a jury, because that's probably where I think the jury should be coming in. You need people to debate these things. So hopefully we'll get to that point with this case. AB 5, signed by California Governor Gavin Newsom in September, says workers can generally only be considered contractors if they perform duties outside the usual course of a company's business. Legal experts say the law weakens Uber's argument that its drivers are independent contractors, and even the company acknowledges the law creates a higher hurdle. I also think that the company itself has been making a strong case that we're not independent contractors for a long time. I mean, the consistent rate cuts, it's all bad. So anyway, Shannon Liz Riordan, one favorite woman, the lawyer representing the drivers and a longtime Uber nemesis, argued AB 5 was passed in order to stop Uber and the rest of the gig economy from misclassifying its workers. Liz Riordan said in an email that she'll refile the complaint and looks forward to proceeding with the case and at last requiring Uber to comply with California law. Chen said it's premature to order Uber to immediately reclassify its California drivers, given that arbitration agreements they signed barring them from pursuing their grievances in court will likely diminish the number who would benefit, which the judge said is still ill-defined. But he refused Uber's request to dismiss the complaint, finding the driver who filed it could form the basis of a lawsuit based on the 2018 Dynamex decision by California's highest court. The ruling applies a more straightforward test to determine which workers qualify for employee status and the attendant benefits. Legal experts widely agree that tests, especially as codified by AB 5, will make it much harder for Uber to continue to deny California driver benefits, including business expense reimbursements that would ordinarily be available to employees. And if you want to look at this case yourself, the case is Calapi versus Uber Technologies, Inc. Here's the information. You can search this up in the U.S. District Court in Northern District of California, San Francisco. So here's the thing. This is kind of refreshing to me. I know a lot of people are probably not happy with this outcome because we want answers. We want it to be defined, darn it. We want to know exactly, are we employees or are we not? And the judge is not saying we are. He's also saying we're not. He is saying he doesn't know. He cannot make that decision right now. And depending on what kind of case this is, I don't even know if he can make that decision. It might be one of those lawsuits that has to go to trial. And in that case, a jury will probably decide. This is how the legal system works. There's different kinds of lawsuits. I don't know which one this is. I think this is just class action, actually, now that I think about it. But, class actions can get pretty ugly. So, yeah, I think the judge made a wise call. He's not saying yes or no. He's just saying we need more information. So that's where we're going to leave it. And what do you think? Do you think the judge made a right call, or do you think he should have done this? What is your opinion on this? And hey, while we're at it, what do you prefer, McDonald's or Burger King? I would love to know. Comment below, like, favorite, share, subscribe. If you enjoy my videos, consider becoming a Patreon member. It's totally optional, of course, but even as little as $1 a month goes a long way to helping the channel run smoothly, and you get access to my private Discord server. If gas prices get a little down, check out the Get Upside up below. It's totally free, but you get cash back on every gas purchase. And if you want more content, check me out, Kevin T. Rodriguez, the Apptrepreneur Vlogs, and Autograph Hound. And finally, if you want to talk to me or other fellow riders or drivers out there, check us out the Apptrepreneur Hangouts on Facebook. And as always, blame responsibly. Have a good one.